This is a case of an elderly couple worried about not qualifying for Medicaid because they have too many assets. Let's take a look at how to resolve this. The case I'll introduce today is about an elderly couple living in California. The husband is currently battling an illness due to old age. They are significantly burdened by caregiving and medical expenses, and the wife is concerned about asset management, particularly regarding the Medicaid program in California. It's called Medi-Cal here. She is worried about the eligibility issues. We conducted a consultation. They want to receive Medi-Cal benefits, but they are worried that their current assets might disqualify them. So when we looked into their asset situation, there are mainly two types: real estate and life insurance. First, they own two properties. They hold them in joint ownership, and one of the properties is, of course, the home they currently reside in. The other property is for investment purposes. It's a rental property. As of now, they are holding on to it, and the second asset is life insurance. It is registered under the wife's name, and since it's an IUL, Index Universal Life, a certain level of cash value has accumulated. Also, the death benefit has significantly increased. So these are the two assets they have. And as for their children, they have a married daughter. They heard somewhere that to qualify for Medi-Cal benefits, their asset size must not exceed a certain level. So they considered gifting their assets to their daughter to reduce their asset size for the Medi-Cal application. However, they are hesitant to make a decision because if their daughter were to divorce in the future, the assets might end up with their son-in-law instead of their daughter. This is a question we receive often. It's a topic for consultation. Therefore, those who are in this situation should definitely use this as a reference and also consider their own case. Based on these facts, it might be a good idea to get a consultation. Now, let's delve into the specifics. Before that, let me introduce this channel. We provide professional information on U.S. law, tax law, and financial planning in an easy-to-understand manner. Not only this video, but we will continue to upload more beneficial content in the future. I hope you don't miss out on it. To keep receiving this kind of information, if you haven't already, please subscribe and like the channel again. For this elderly couple, what is the most important thing? First, you need to know the asset requirements that Medi-Cal demands. For example, there will definitely be a monetary threshold, and you need to find out whether it refers to all the assets you own or if there are exceptions for certain assets that are excluded. So, if it seems like you have too many assets to qualify, you need to find out if there's a way to reduce them. So, from this perspective, let's take a look at each one. First, let's look at the basic regulations. There are a few. The first basic regulation. What is it? Medi-Cal is essentially a Medicaid program, but since it's a program run by the California government, it's called Medi-Cal. You can consider them the same. Other states have similar programs. So keep that in mind as you listen. Let's take a look at the eligibility requirements and asset criteria for those who qualify for Medi-Cal. Medi-Cal is California's Medicaid program, and the income and asset requirements are quite strict. So, for an individual applicant, the current asset limit is $130,000. And if a couple applies jointly, the asset limit increases by $65,000. In other words, for a single-person household, the asset limit must be within $130,000. For a two-person household, it's $130,000 plus $65,000, which totals $195,000. For a three-person household, it would be $65,000 times 2 added to the base, making it $260,000. In any case, that's how the calculation is done. Therefore, in the case of the elderly couple mentioned earlier, it means they can hold up to $195,000 in assets without exceeding the asset limit. For Medi-Cal eligibility, then we need to look at what constitutes the assets that are evaluated for Medi-Cal and what types there are, right? What goes in is this. You can look at about 5 things. First, cash and deposits. This includes checking accounts and savings accounts. Next, the second is investment assets. This includes stocks, bonds, and mutual funds. Third is life insurance with cash value. Whether it's whole life or IUL, insurance products with cash value are also considered assets. And then there's other real estate. This means that real estate owned for investment purposes aside from your residence is also counted. Additionally, business equity, vehicles, and precious metals are also included. Now, what should be noted here is the primary residence. The primary residence where you live is exempted. So, for California Medicaid rules, the home where I or my spouse actually resides is, I'm talking about a provision that generally states that these assets can be excluded from evaluation. Now, you might start thinking this way. Okay, I understand the asset, amount, criteria, and what is included. Then, to reduce this, I might consider transferring my assets to someone else, or finding another way to meet these conditions. Of course, you could do that, but does the government just say, go ahead? No, that's not the case. It's called the look-back period. This is the third point. It's similar in other states, but in California. From a Medi-Cal perspective, when evaluating assets, they generally investigate asset transfers over the past 30 months. So, during this look-back period, if assets are transferred within those 30 months, it's called a penalty period. This means that receiving Medi-Cal benefits could be delayed or limited. So, up to this point, we can summarize it like this. In other words, Medi-Cal, which is Medicaid, there are certain asset conditions, as I mentioned earlier, and you must not exceed these limits. The assets generally include these types, but the primary residence is excluded. And to prevent people with substantial assets from transferring them to others' names, to enjoy these benefits, a penalty period known as the look-back period is implemented. So, is this the end of it? No, it's not. What is it? Especially regarding the primary residence. Even the primary residence is not completely exempt. There is an issue of posthumous recovery. What this means is, when a person who received Medi-Cal benefits passes away, the amount spent by the Medi-Cal program during their lifetime is considered. Among them, there are amounts paid specifically for long-term care services. This refers to long-term care. In this case, the cost of long-term care services received by a Medi-Cal beneficiary after the age of 55 is subject to recovery after death, and the assets subject to recovery after death include the primary residence. If the surviving spouse continues to live in the primary residence, it is exempt. However, once that spouse also passes away, it can be subject to recovery, which is a limitation. Or consideration, I wanted to point out that there is such a consideration. So, the fourth point is that the primary residence is not completely exempt. So, I've explained these 4 basic rules. Let's go back to the facts. What was the issue with this elderly couple? First, they might not qualify for Medi-Cal because they own 2 properties, one of which was considered a primary residence. And then, they also had an insurance product with cash value in an IUL. So, the first issue is that they are likely to exceed the asset limit. And the second issue is whether they should make a direct gift. They considered this for their daughter. However, if the daughter were to, hopefully not, but possibly face a divorce or financial issues like bankruptcy, debt, or lawsuits, the assets could be lost. There's the risk of having to bear such issues, and thirdly, the matter of posthumous recovery. They talked about Medicaid recovery. After the beneficiary's death, certain assets are recovered to cover long-term care costs, so there needs to be a strategy to protect these. So, the next question is, how can this be resolved? What solutions are there to resolve this situation? I am going to talk about 3 things now, so please listen. The first one is direct gifting. There are limitations that I mentioned earlier. Nevertheless, transferring the title of this real estate, it would be a situation where you directly transfer it to your daughter or transfer the ownership of a life insurance policy to her. The advantage is, of course, that the procedure is relatively simple. And since the asset is being removed from the couple's name, the likelihood of passing the Medi-Cal asset evaluation increases naturally. And also because the title is completely transferred and ownership changes. After death, the risk of recovery, the Medi-Cal recovery risk, can be said to be significantly reduced. But of course, the limitations are also clear. As I mentioned earlier, it must not be within the look-back period. Also, if your daughter encounters any issues later, whether it's a divorce or debt problems, it won't be protected. Another important point, although it may not be significant depending on the situation, is that since the asset is completely gifted, you lose control over that asset. If by any chance the couple wants to use it later legally, since the gift has already been completed, they won't be able to do so, which is another limitation. The next method, the second one, is this. This is also a question I get asked a lot. Something you might want to keep in mind is the Medicaid Asset Protection Trust. It's also called a Medicaid Trust or MAPT. There is a separate video on this, but today we're covering it again. The concept is this. It's an irrevocable trust designed for Medicaid asset protection. Ultimately, this means that the couple does not directly own it. By establishing a trust, the trust becomes the owner of the assets that the couple previously held. The couple has now transferred their assets to the trust, and because it's an irrevocable trust, they must relinquish direct control. Instead, the trustee managing the trust will handle and operate the assets within the trust. So, what are the advantages of setting up and managing this MAPT? First, the assets transferred to the trust. Provided that the look-back period has passed, the assets in the trust will be excluded from the assets evaluated for Medicaid. And as mentioned earlier, compared to directly gifting assets, since it's not a direct gift to the children, it can protect the assets from personal circumstances like a daughter's divorce or financial issues, debt problems, etc. Additionally, there is a high possibility of avoiding assets being subject to Medicaid recovery after death. These are the advantages. On the other hand, the disadvantages are as follows. Ultimately, you still have to appoint a separate trustee. At least, legally, you have to consider that you are giving up direct ownership or control over your assets. And since this trust is an irrevocable trust, after all, there are costs associated with setting it up and managing it. You have to consider that costs will arise due to the complexity of legal documentation and other such tasks. Also, as mentioned earlier, you need to surpass the look-back period, and if not, there could be penalties which can be seen as limitations and points of caution. Nevertheless, utilizing this trust is considered to be much more effective than direct gifting or other methods. And thirdly, this is the last point. This is also very important. What it is buying an annuity. This is called a medical compliant annuity or MCA. It's not a regular annuity. You use real estate or cash assets that you own directly. You immediately convert these into an annuity, meaning you use your investment funds to purchase the annuity. When assets are transferred into an annuity like this, they are removed from your assets. You understand what I'm saying, right? So, in the case of this couple, the real estate or life insurance assets they own exceed the asset limit from the perspective of Medicaid, which is the problem. But they plan to liquidate these and use the funds to purchase an annuity product. Then, since the annuity is excluded from the assets, the asset size will decrease. So, they will be able to qualify for Medicaid. And since they bought an annuity, they can receive income. It's good because it ensures a stable income. For me, this annuity is not just any regular annuity. It's called an MCA. It refers to a specific annuity that we can purchase for this purpose. So you need to know that, but the pension income you receive here, the income you receive from the annuity, can also affect the income criteria used to evaluate eligibility for Medi-Cal. Therefore, it's important to carefully consider how much MCA you secure to utilize it in meeting the asset and income criteria for Medi-Cal eligibility. And if it becomes a valid strategy, it's worth considering purchasing this MCA to secure eligibility. Another good point is this MCA is not subject to the look-back rule. However, if you use it to purchase the annuity with the assets you currently have, there's no penalty applied, even if you bought it within 30 months. That's why it can be considered a better method compared to options 1 and 2. To summarize, when considering Medicaid benefits for an elderly couple residing in California, a good approach is to address their concern about having too many assets and the worry about giving them to their daughter. The solutions here are: first, despite the concerns, directly gifting the assets. Second, establishing a Medicaid Asset Protection Trust, MAPT, for Medicaid purposes. Or third, considering the purchase of an MCA Medicaid-compliant annuity that can help meet asset requirements. The important thing is, it is necessary to carefully consider the look-back period mentioned earlier, the financial risks to the children, and the potential loss of direct control over the assets by the couple, and make a cautious decision. So, even if there are somewhat many assets, by considering these factors and setting an appropriate strategy, you can take advantage of the benefits and simultaneously ensure the safety of the family's assets. I think it would be beneficial for those who are applicable to review this information and consult with those who can assist, if necessary. That's all for now. I hope today's content was helpful. I believe there are people around you who need this kind of information. This channel is one that aims to grow continuously with you. Please support us with a subscription and a like. We ask for your help in ensuring that you receive the necessary information next time, and that it can also be shared with those around you. Thank you.